I see the numbers have just gone above 50, and it's now after, in fact, they've gone up to 55. It's now just after 5 o'clock. So given that one of our speakers needs to finish by 6, I will commence. I think we're currently planning to run till 6:15, but obviously if the numbers drop away, then we will bring it to a close. But just to introduce me, I'm the chair of the Bar Council European Law Committee and have practiced in this area for a while, but I'm here very much to introduce our speakers. There are obviously an enormous number of topics that we could have chosen in terms of substantive law, but we've tried to choose 2 which are of very wide general interest and importance: civil judicial cooperation and data processing, and how the end of the transitional period will impact on both of those. And we are extremely fortunate to have assembled a stellar galaxy of speakers from both private practice and academia and the government. And I'm very grateful to all our speakers for giving up their time to share their expertise with us. In relation to CJC, we have Ivana Fruithof, who has been for many years the Bar Council's representative in Brussels and has been our eyes and ears on the ground within the European Union and has been enormously valued by successive chairs and committees in that role. We're then followed by, she's then followed by Jonathan Harris, Professor Jonathan Harris, who is, I think, without doubt, one of the preeminent experts in this field, currently editing Dicey and Morris, having a chair in international law at King's College London, and also a tenant at Searle Court. So we're extremely grateful to him. And then finally on this topic from the Bar, Fergus Randolph, who I think will be known to many of you as one of the leading silks in the field of EU law. Once upon a time he was at the Brick Court Brussels office, and then for many years has been in London, and now I think is both in London and Brussels. And so he has a particular perspective on all these questions. And then to wrap up this topic, Paul Norris, we're very grateful to him. He is the policy lead in relation to this area at the MOJ, and so he will be in a position to pick up the topics that have been raised, although obviously there are certain uncertainties and constraints in relation to the government and what they can say at this stage, but we're very grateful to him. And then we'll aim to be about half an hour in relation to that, and then we'll hand over to Rupert Paynes, who is a very busy junior in this field at 11 Kingsbench Walk. For example, he appeared for the Information Commissioner in the Cambridge Analytica Facebook matter, which is obviously of great interest, and he's been the go-to man for the Bar Council in relation to this area, so we're grateful to him. And then finally, Sam Green from DCMS, who is a business advisor to industry in relation to the consequences of the end of the transition period in the field of data. So as I say, we could hardly have got a more expert group together to address these important topics. And our 3 first speakers, I've thought of them as Christmas past, Christmas present, and Christmas yet to come. And I don't want to frighten you, but of course the moral of that tale is that you need to get ready and change your life if necessary to anticipate what may be coming down the track. So I suspect that's going to be the moral of this story as well. So I'll pass over straight away to Ivana to look at the current position before looking to Jonathan and Fergus to look to the future. Thank you. My last role as chair is, if you do have questions, can you use the chat function rather than the hands up function, and we'll try and deal with your questions if time permits at the end. Thanks very much.
Thanks, Rodri. I apologise in advance. My link isn't great, but I'll try and plough through this as quickly and cogently as possible. I'm going to give you, as Rodri just said, a sort of a view of the present situation and why this is important. So the first question is, why is the end of transition a problem for cross-border civil litigation as between the EU and the UK? And the answer is broadly that as of the Amsterdam Treaty coming into force in 1999, the EU has been legislating in civil justice fields, taking several instruments that used to be intergovernmental into community competence. There are several cornerstone instruments that you're probably very familiar with, like the Brussels I recast on jurisdiction and the recognition of enforcement of judgments, Brussels IIa concerning jurisdiction and the recognition of enforcement of judgments in matrimonial matters, and the maintenance regulations similarly for maintenance. These have all made cross-border litigation simpler and more predictable, reducing the risk of race to court, having competing and parallel jurisdictions, ensuring that judgments are automatically recognized and enforced in other member states, and indeed assets are available to enforce against. And in the family law field, especially in very urgent cases, of course, the fact that cases are quicker is very useful. The overarching private international measures I've just mentioned have over the time been supplemented by lots of civil procedural measures, such as the European Small Claims Procedure, European Enforcement Order, European for personal injunctions, and so on. And of course, last but not least, as we'll hear from Rupert, in the justice field also, we've got the General Data Protection Regulation. So that's a lot of very valuable measures, all of which in effect stopped applying to us as of the 31st of January 2020, when we no longer were a member state of the European Union. However, the terms of the withdrawal agreement of 2019 extended our rights and obligations, including in civil justice field, to the end of the transition period, which, as you all know, ends on the 31st of December. So in an ideal world, what the Bar Council was pursuing and was hoping for was a separate EU-UK agreement in which much of the existing EU justice acquis would have carried on, precisely because it is so valuable. But because of the UK's red lines, especially in relation to the ongoing jurisdiction of the Court of Justice, and the EU's insistence on this being a single market issue, that hasn't been possible. And we've seen that through the lack of ambition in the civil justice field, through various different mandates, and in the political declaration on the future relationship, which was agreed alongside the withdrawal agreement last year. And indeed, the EU has a fairly hard line issue on this, and it sees legal services and the loss, the problems that are likely to arise in this area as being collateral losses from Brexit. So the view seems to be that they'll look to see how bad it's going to be, and especially from an EU citizen and business point of view, how bad it is, and then potentially reassess. So there's an element of that. That's a very hard line perspective, but nevertheless, it is one that is held by some. So therefore, what we're looking at is a situation where there's likely to be no comprehensive civil justice arrangements in place by the end of this year. And it's too late, and Fergus will explain this in more detail, I'm sure, to join Lugano by the end of this year, which would have been an alternative, as Fergus will explain. And as a result, therefore, we're looking at what we call a cliff edge for civil justice at the end of the year. So then you're looking at falling back on national instruments, as well as any existing international conventions between the different parties. Therefore, we're looking at a situation where there's potentially going to be races to court. You're going to have different courts considering themselves to be competent. There might therefore be irreconcilable judgments. No court having jurisdiction to hear a case, recognition enforcement becoming expensive and tortuous, etc. And moreover, there's also the likelihood that we're going to have a situation where you go from the Brussels regime and the rest of the EU acquis at the end of this year to national law plus existing conventions right at the beginning of January. And then if there is a solution between the EU and the UK sometime in the early part of next year or thereafter, then into a third set of rules which apply from then. So you're looking at 3 potential changes of rules in this area over potentially a few months, and that's going to, as you can imagine, lead to potential litigation chaos. But Jonathan and Fergus will cover all that in more detail. So what I'm going to look at is what you can do in the next 9 weeks to potentially avoid some of this. If you are involved in a case that is already pending or advising in a case in which proceedings will soon be launched in reliance on one or either of these instruments, is there anything you can do? Yes, the answer is yes. Before the end of transition, you can take steps to preserve your client's position. What you need to do is look at the withdrawal agreement itself, Article 66 to 69. Article 66 deals with applicable law, and it effectively says that the Rome I regulation will apply as it would have done before for contracts concluded before the end of the transition period. Rome 2 will apply in relation to applicable law in relation to events where giving rise to the damage, provided the events occurred before the end of the transition period. And then in relation to jurisdiction, Article 67 preserves the application of the jurisdiction provisions of Brussels I recast of Brussels IIa on matrimonial matters of the maintenance regulation, and indeed of the data protection regulation in certain circumstances. In the UK, as well as in the member states, in situations involving the UK, in respect of legal proceedings instituted before the end of the transition period, and in respect of proceedings or actions that are related to such legal proceedings. So, for example, in the family law field, that means that if a divorce, children or maintenance claim has been commenced before the end of this year, jurisdiction and prior form will remain in place, and there shouldn't be a possibility for somebody else to try to oust that. So you basically need to make sure in relation to jurisdiction that that proceedings are issued before the end of the year. In relation to recognition and enforcement, Article 67.2 extends the protection for pending cases of the provisions of the above measures, as well as for small claims, European Protection Order, and other provisions, including insolvency. So again, provided legal proceedings are commenced before the end of 2020, recognition and enforcement in the UK or the EU as applicable will continue. However, the question is which proceedings need to have been launched by that deadline in relation to recognition and enforcement. There was a question mark earlier on in the year as to whether it was enough if the original proceedings had been launched, or it was necessary to actually launch the separate proceedings for recognition and enforcement before the end of the year. The Commission issued a preparedness notice preparing for the end of transition 27th of August of this year, and that is a practical guide dealing with loads of different aspects of civil justice, but it also clarifies that question and indeed confirms that launch of the original proceedings by the 31st of December is sufficient to get the protection of the withdrawal agreement. So that's my main takeaway basically for today. Make sure if you have got a case that could potentially benefit from those provisions, that proceedings and the relevant proceedings, that is, are launched by the 31st of December. Now, just to note that there are also provisions under Articles 68 and 69 in relation to EU mutual assistance measures like the taking of evidence, service of documents, civil and other civil procedural measures. And there too, the same applies, but you need to make sure the particular measure has been launched as opposed to just the overall proceeding. So if you think your case might benefit, please do have a look at the withdrawal agreement, specifically Articles 66 and 68, as quickly as possible, and also look at the Commission preparedness notices and other sources so that you fully understand, because there's been a lot of discussion about interpretation. Just also to say on interpretation, before I hand over to Jonathan, that the prepared notices do go on to examine the various post-transition scenario, including detailing existing international conventions and when national law might apply. There also, we have noticed important differences between how the UK and the EU are interpreting the position, for example, in relation to the Hague Choice of Courts Convention 2005, and when that in fact enters into force for the purposes of the UK. And on that, I will happily hand over to Jonathan. Thank you very much.
Thanks very much, Ivana. So I think the plan of action is that I'm going to talk about many of the changes to English law from the 1st of January 2021. And then Fergus is going to pick up on that a little bit further and look a bit further into the future as to what may happen next. So firstly, working its way through Parliament is the Private International Law Implementation of Agreements Bill 2020. Now, for something that is essentially administrative, I would say, in nature, it's caused an awful lot of political controversy and had a rocky ride, and particularly when one learns that the entire bill consists of a grand total of 2 sections. The first section of the bill, which has not been particularly controversial, just deals with the fact that the UK is party to a number of international conventions because of the exclusive competence of the EU, which ratified it on behalf of all of its member states, and needs instead to become an independent party to those conventions and to implement and make some consequential amendments to domestic law. And Section 1 of the bill does that, and will be the means in particular through which the UK can give effect in domestic law to the Hague Choice of Court Convention 2005, which Fergus will tell you more about, and the Lugano Convention 2007, if, and as we've learned from Ivana, it's very much an if at the moment, the other contracting parties, including the EU, give their consent to the UK joining that regime. The second section has proved to be a little bit more controversial. I mean, its aim is essentially to provide a mechanism to incorporate and implement international conventions and model laws, which the UK has decided to become party to into domestic law, without affecting the legislative scrutiny of Parliament in the first place as to whether the UK should ratify those conventions or not. This led to the House of Lords effectively voting to take out one of this second section on the basis that they didn't think there was a justification for using secondary legislation for questions of this order, and they expressed concerns about the uncertain ambit and the scope of this power. So it went back to the Commons with these provisions in Section 2 of the delegated legislation power removed. The House of Commons has put them back in again, and that was finalised on I think the 6th and 7th of October. So now the bill has gone back to the House of Lords for the ping-pong procedure, but one anticipates that the likely outcome in the end is that we will have both Section 1 and Section 2 of the bill. But like I say, the primary function of the PIL bill is administrative, to deal with the need to implement conventions in domestic law. What else happens from the 1st of January? Well, the easy bit is choice of law, but we oughtn't to forget it. The Rome I and Rome II regulations deal with applicable law related to contractual and non-contractual obligations, respectively. And of course, Rome I in particular deals with the effects of an English choice of law clause. And happily, the position is very straightforward there. The Rome I and Rome II regulations will be incorporated into domestic law and will continue to apply seamlessly. And nor do you need to worry that the member states will start giving less effect to English choice of law clauses, because both Rome I and indeed Rome II apply in the member states, regardless of where the parties are from, and even if the chosen law is not that of a member state. So it's as close as you can get to business as usual for English choice of law clauses. But of course, as Ivana's already indicated, the real difficulty is in relation to jurisdiction and judgments. It would not have made sense for the EU Withdrawal Act unilaterally to have incorporated the recast judgments regulation into domestic law, because it would have meant the UK continuing freely to recognise judgments from all the other member states, with a complete absence of any reciprocity in the absence of an international agreement. So it is not being incorporated into domestic law. So you might think that the position from the 1st of January is very simple. We're just back to where we were before 1972. Everything is governed by common law, rules of jurisdiction and enforcement. That is not, however, quite the case, because there are a raft of statutory instruments covering the field of private international law, which will kick into effect from the 1st of January and effectively set out our default English law in all areas that are not covered as of that date by international conventions. Probably the most significant for present purposes is the civil jurisdiction and judgment brackets amendment close brackets open brackets EU exit close brackets regulations 2019, let's call them the CJJA regulations. And although, again, a lot of that is administrative, about unravelling the direct effect of the judgments regulation, there is.
Should we say 7 o'clock?
I shall continue. There is one very significant substantive change, and that is this, or perhaps I should say substantive continuation. Although we will very largely fall back on the common law rules from the 1st of January, it was thought inappropriate to deprive UK domiciled individuals, weaker parties, consumers and employees of the benefit of the rules that they currently enjoy under the recast judgments regulation. As many of you know, they enjoy privileges that businesses and individuals in commercial contracts do not enjoy. Consumers in particular are normally entitled, have the right to bring proceedings if the preconditions in the relevant articles are met in their home courts against a business. And under the recast regulation, they can do that regardless of where in the world the business is domiciled. And jurisdiction clauses in consumer contracts will rarely be effective, save in very prescribed, tightly prescribed situations. And of course, if you think you hardly ever deal with cases involving consumers, one needs to be careful, particularly in the light of recent ECJ authority. A consumer is anyone doing anything for a purpose outside their trade or profession, even if that is seemingly an oligarch who wants to speculate billions in futures with their private wealth. So the scope of those articles is wide. And likewise, the employment rules of Brussels are being enacted into domestic law so that UK domiciled employees continue to retain the benefit of the more generous regime as against employers. But with that exception, and subject to what Fergus will tell you about the Hague Choice of Court Convention, the default position is indeed from the 1st of January, we all go back to the common law. Now, Ivan has already highlighted this. If I may, and if the chair tells me I have enough time, very quickly I will just give you half a dozen take-home points as to what will change when we go back to the future and have more of the common law from the 1st of January. Firstly, the position we enjoy, if that's the right word, under the recast judgments regulation, providing very wide and indeed automatic almost protection for English jurisdiction clauses, whether exclusive or non-exclusive or almost any kind of hybrid, will come to an end. That protection is two-sided. English courts, which is rather self-evident, have to uphold and take jurisdiction where there's an English jurisdiction clause. But just as importantly, the courts of other member states currently have almost automatically to decline jurisdiction if there's an English jurisdiction clause. We will lose that, and we will lose the benefit of the latest amendments in the recast regulation that prevent the so-called Italian torpedo of parties trying to undermine an English jurisdiction clause by starting proceedings in a foreign court in another member state, which may take forever even to make up their mind whether they have jurisdiction or not. Whilst in the meantime the UK courts are powerless. That problem was corrected in the recast regulation. In truth, it's fair to say that the bigger issue is that we will lose automatic protection of English jurisdiction clauses on the continent, but subject to the Hague Choice of Court Convention. Secondly, and I don't think I need to say much about this, Ivan has touched on this, the court first sees rule, love it or loathe it or somewhere in between perhaps, that automatically means first come, first served in most cases around the European Union, will obviously come to an end as between the UK and the EU, which means you could, as Ivana says, get parallel proceedings in England and on the continent, and you could get a greater risk of irreconcilable judgments, which really follows hand in glove. Number 3, well, apart from the areas covered by international conventions, as I said, we're going to be looking forward to return of the common law rules of jurisdiction to across the board, even to defendants who are domiciled in member states where those rules haven't applied since 1987. It's not necessarily a huge problem. It means more applications for service out of the jurisdiction with permission. It may mean more forum non-convenience. Disputes is not the end of the world, though, of course, we all know how many disputes are brought in England involving defendants who are not domiciled in the EU at present. It doesn't seem to put that many people off, but it will be a more cumbersome procedure. Fourth, the fetter that the ECJ has imposed in Turner and Grovet on restraining proceedings in the courts of other member states, precisely where proceedings have been started for tactical reasons in a slow jurisdiction, or in breach of a jurisdiction clause, or for any other vexatious reason, and can't be brought to an end by an English court, that restriction will be lifted. In principle, absent any other deal, there will be no fetter on the use of anti-suit injunctions to restrain parties from proceeding in the courts of member states. Fifth, and again, Ivana's touched on this, but it's so important it can scarcely be understated, we will lose the automatic right to enforce English judgments in the courts of other member states. There's no exequatur procedure under the judgments regulation. It's a judgment of an English court in the right form and with the right forms attached. It's pretty much like a passport that you wave at a judge in a foreign court and hey, for presto, you have an judgment. We will lose that. We will, for the most part, go back in England to applying the common law, more restrictive rules for enforcing judgments from member states, although not entirely, as there are some limited bilateral treaties that will revive, but they're not of wide ambit. But of course, perhaps more significantly, if you want to know how to enforce an English judgment in any of the member states, you will have to go and get advice, because it will become a matter for national law about what the substantive and procedural criteria are under national law. All of this leads to a point that Fergus is going to pick up very, very shortly, which is the concern, which is not just for disputes, those of us involved in disputes, but for those who are drafting. The concern has been that this uncertainty might cause some people to move away from contracts choosing English courts, and maybe because they go together, choosing English law as well, and start looking at other options to eliminate the uncertainty as to what might happen. And one of those possibilities, certainly, and it was identified in the House of Lords EU Select Committee report on the subject, is we may see even more people opting for arbitration and English arbitration clauses. And the main reason for that, of course, is that arbitrators are largely unaffected by this raft of legislation. It doesn't apply more or less to them. And indeed, if the UK doesn't join the Lugano Convention, and it will cease to be bound, as we know, by the recast judgments regulation, English courts too will regain the power to restrain perceived breaches of English arbitration clauses in the courts of other member states, as they were infamously
Jonathan,
West Tankers. I'm just wrapping up.
I think you're straying into your time now.
Okay. So I think that's about it, but it obviously is subject to the caveat that the position on English jurisdiction clauses is subject in particular to the Hague Choice of Court Convention, and I'll hand over to Fergus.
Thank you. Thank you very much, Jonathan. Seamless handover, and I will be brief in view of the time. Just one small point. We keep on mentioning the end of the transition period being the 31st of December 2020, in 9 weeks' time. It will actually, for the UK, be on UK time, so it'll be 11 p.m. So 1 second past 11 p.m. we will have concluded the transition period, so don't forget that. I'm going to deal with three conventions. We've had very clear exposés of the present position and what will be the position under common law. And so I'm going to look at the Hague Choice of Court Convention, 2005. I'm then going to look at Lugano, and then I'm going to come back to The Hague, but 14 years later, in terms of the 2019 convention. The Choice of Court Convention will be relevant probably for a very short period of time. As we've heard, at just after 11 p.m. from the 31st of December, the Brussels regulation recast dealing with jurisdiction and recognition and enforcement of judgments will fall away, apart from runoff proceedings, which Ivana has mentioned. which means that legal certainty will less obvious. In its place will come Hague 2005, which came into force on the 1st of October 2015. It's not as far-reaching. It's not as good as the Brussels regulation, not least because it only covers exclusive choice of court agreements in civil and commercial matters and excludes, amongst other things, consumer and employment contracts, IP disputes, PI cases, which is important, and competition claims. For matters that are covered, i.e. the rest, the Convention obliges the contracting parties to give effect to the relevant, exclusive, underlined jurisdiction provisions and to recognise and enforce judgment from those chosen courts. The ratifying parties to the Convention are the EU and its member states, Mexico, Montenegro and Singapore. The UK remains an EU party during the transition period. Afterwards, so as of the 31st at 11 p.m, it will accede qua independent third country to the Convention. There is one problem. There is one problem, and that is this. Does it have retrospective application? In other words, will its provisions apply to exclusive jurisdiction, exclusive choice of court clauses between the 1st of October 2015 when it came into force and the 31st of December 2020 at 1 minute past 11 UK time, or will it only apply from that latter time? Now, the UK's position is, guess what, goes all the way back. That's not shared necessarily by everybody else, and certainly not the EU. So what's the summary? Not perfect, limited, sticking plaster solution, waiting for something better on, and litigation in the offing, retrospective application. So that's a smiley face potentially for members of the bar and solicitors. So what is something better? What's something waiting to come along? That's the Lugano Convention. Now, Lugano would be brilliant. Well, as brilliant as things can be in Brexitshire. It would be not a bad deal. It's not as good as Brussels recast because it doesn't totally reflect Brussels recast. It reflects the position before Brussels recast. But nonetheless, it gives a great deal of legal certainty, and one has a large degree of case law to fall back on. So legal certainty is a positive. However, unlike Hague 2005 and Hague 2019, which I'm going to come on to in less than a minute, one has to have the agreement of all parties thereto to Lugano. And one of those parties, apart from the EFTA states, is the EU. And the EU has been holding out, surprise, surprise. So there will be a gap. Because even if Monsieur Barnier was convinced today to change the position of the EU and say, yep, we're going to agree to the UK's application to accede, there is a 3-month gap. And we are now the end of October. So there will be a gap. Present indications, and Paul Norris from the MOJ, the next speaker, will be able to give more details on this. But as we understand it, if all things go swimmingly, best indications are for spring 2021. So as Ivana said, we will have a situation of where we are now, a very short period, hopefully, fingers crossed, when we just have Hague 2005, and then maybe, hopefully, we can enjoy the waters off Lugano. So summary, much better than 2005 Hague Convention. However, we are in the hands of the EU. Finally, 2019 Hague Convention. This was concluded not very long ago, July 2019, and has been described as the court equivalent of the 1958 New York Convention for the Recognition and Enforcement of Arbitral Awards. It's a truly global, or the aim is to produce a truly global recognition and enforcement mechanism. Its scope in terms of claims covered is similar to the 2005 Hague Convention, except PI cases are not excluded, which is important for members of the bar. The problem for the UK, though, is the accession process. The convention presently has 2 signatory states. Now, you may laugh and may say, well, that's not very many, but that doesn't matter, actually, because all you need is 2 signatory states who then subsequently ratify or accede for the convention to come into force. So Uruguay and Ukraine have signed up. The EU has stated publicly that it's game on, but that may well take some time. For Hague 2005, it took 4 years for that to happen. Summary would be useful for the UK in terms of global enforcement. It's not going to cover not going to be necessarily a massive add-on for the EU. Time isn't on the UK side. It will take a substantial period before the convention comes into force and before the EU accedes to it. And so it's not a short term. I conclude, even with a deal, and we don't know, but the signs are looking better than they were a few weeks ago, there will be a gap. There will be a cliff edge, which will doubtless have to be exploited by clever lawyers and willing clients. So there'll be a gap at the end of the transition period, when issues of non-exclusive jurisdiction and recognition and enforcement of judgments will be governed by the old common law rules, and we've heard from Jonathan about that. We've also heard, luckily, that one thing stays the same: Rome 1, Rome 2. So at least that is good. There is liable to be a certain amount of foothill litigation in relation to, amongst other things, the retrospective scope of 2005 Hague Convention. We're in the EU hands, re Lugano, and I may well have retired by the time the EU accedes to the 2019 Hague Convention. Thank you very much.
Thank you very much, Fergus. Can I just interject that as of now, I don't think I've received any questions. So if people do want to raise questions, that would be we'd be grateful for it. There's a lot of material here, so it's possible we won't get through it all within the time, leaving enough time for questions. If you nonetheless have questions, then do feel free to send them to us, either on the chat function or by email, and we'll do our best to respond to them. But I'll now hand over to Paul to say something from the government perspective, possibly responding to what he's heard so far, but I'll leave it to him. Thanks very much.
Yeah, thank you very much, Rodri, and thank you for inviting the government to be on the panel. I do hope, from your metaphor that you opened with, if my colleagues who preceded me are the ghosts of Christmas past, present and future, that doesn't make the government Scrooge. But I will let observers make their own mind up on that. There are a few points that I've noted down as the 3 excellent speeches were being given to just add some colour or add the government perspective from. The first is this double change point that Ivana raised in her opening remarks, in terms of a situation where we leave the Brussels acquis at the end of the transition period, and then a potential further change down the line if we are successful in acceding to Lugano, and the effect of a double change, and the potential for confusion in that intervening period. And I think we recognise that is a less than ideal solution, and everybody on the government side recognises that. Ministers have taken the view actually that it would be a price worth paying for getting back into Lugano at a point in the spring of 2021, and I'll come on to that next. In terms of timing on Lugano, as colleagues have already said, and Fergus laid out quite clearly, we need the EU to take a decision. At the moment, it isn't, as far as we understand, that there has been a decision taken within the EU not to let the UK in. It is very much the case that they are waiting to see what the overall future relationship may or may not end up looking like, and a decision from Lugano and on our application to Lugano is probably sort of waiting for resolution of the future relationship negotiations before it will be taken. So I think in the best case scenario, we would hope we get a decision before Christmas, but it isn't inevitable that we would definitely get a decision on the Lugano application specifically before Christmas, even though we know that there will clearly be a resolution one way or the other in the next couple of weeks on the wider future relationship. In terms of what that means for an implementation date, yes, a best case scenario is sometime in the spring of 2021. Obviously, our aim is at the point that we get a decision, in the event that that is a positive decision from the existing contracting parties, including the EU, to be in a position to move as quickly as possible to keep that sort of lead-in period to the sort of 3-month minimum, if at all possible, and that is what we will try to do. And we are doing lots of preparatory work behind the scenes in MOJ to be as ready as we can to press go the moment we get a decision. There was just one point I wanted to pick up that was related to Lugano on the private international law bill, which Jonathan touched on. I think Jonathan said that that clause 1 of the bill does the domestic implementation for Lugano as well as Hago 5. It actually doesn't. There was an amendment to try and make it do so in the House of Commons, but that amendment wasn't successful. So while Hago 5 implementation is in that clause 1 of the bill, the government's intended mechanism for implementation of Lugano 2007 would be through the delegated power in the clause 2 part of the bill. Just one further point on the wind down provisions. Again, Ivana talked about the wind down provisions at the end of the transition period that are set out in the withdrawal agreement. People may notice that the SI that Jonathan very articulately read the whole title of previously, and I think he probably knows it better than I. That SI currently, people may notice that the provisions for transitional cases in that SI do not reflect the withdrawal agreement. That is something that will be changed by a further amending SI before the end of the transition period. But if people are confused, it is the withdrawal agreement provisions that prevail, and they should be the provisions that people are looking at when advising their clients. And ultimately, the SI will be brought into line before the end of the transition period. And just a final point before I wrap up. Was to, looking ahead as we've just done in Fergus's discussion towards Hague 19, and I hope I'm not retired by the time the EU takes a decision on Hague 19. But I think it's also true to say that while the government absolutely recognises the benefits of Hague 19 and the potential advantages that it could provide to the UK in future, before we take any final decision, we would both want to have a proper assessment of the traction that it's gaining among other countries. As Fergus has mentioned, so far it's just the Ukraine and Uruguay who've signed, and we would also want to make sure that that we've done a proper engagement process with stakeholders to understand any areas where we might need to just tweak things in declarations and reservations or whatever else before we take a final decision on Hague 19. So the government is, looking upon it positively, but there is no final decision taken here on that, as much as Fergus explained, the EU is yet to take a final decision as well. But something that could potentially be a longer term part solution in this area. I think that was all I was intending to cover, Rodri, so I will hand back to you.
Well, I'm very grateful to all our speakers. It is, at least to the people who don't deal with it every day, quite an intractable area of law, and there's obviously a great deal riding on it and a great deal of change that's going to take place in the next few weeks and months. So I'm very grateful for you to drawing these strands together so well. And as I say, I haven't as yet got any questions, but if you do have questions, then this is your chance, because you're unlikely to get a more distinguished panel available to take them. So do feel free to ask any questions that are in your mind. Having said that,
sorry, Rodri, there is a question in the chat
from Malcolm Jarvis at 1844. What domestic law provisions? Yeah,
it's just come in, and it's quite a specific question. what domestic law provisions implement Articles 66 to 9 of the Withdrawal Agreement and Rome 1 and Rome 2? I don't know if anyone knows the answer to that straight away. I'm afraid I can't tell you straight away. But
so the withdrawal agreement articles are within the European Union Withdrawal Agreement Act 2020. I don't have the exact reference, but that's the legislation in which gives effect to the withdrawal agreement. Rome 1 and Rome 2, that is one of the statutory instruments that Jonathan referred to earlier. I don't think it's the exact one that he gave the title to, but it is in one of those statutory instruments. And I will, while the next speaker is speaking, I will try and get the correct title to that statutory instrument and put it in the chat so that the questioner can look it up in his own time.
Well, I don't know if that's going to stimulate a flurry of questions. If you get such a direct question with such a direct answer, it's almost the first time I've ever seen that in a legal seminar, but that's excellent. So subject to that, I'll pass over to Rupert in relation to data protection.
Sorry, Rodri, there's another question that's come in. Maybe
Christian, I'm going to move on now.
Okay, fine. Okay.
We'll take any further questions at the end. So I'll pass on to Rupert.
Thanks, Rodri. I suppose I should start at the end, as it were, and say that unfortunately I have to jump off this at 6. And I understand that Sam, who's very kindly joined us from DCMS, would prefer to have questions in writing. So if people do have questions, stick them in the chat function and we can have a look at them afterwards and get back to you. In terms of data, there is some change. Probably not quite as much change as we've just heard in relation to the CJC side of things. Really, I've got 4 key points for self-employed barristers who are really the intended recipients of this talk. Firstly, the GDPR isn't the only information security obligation out there, and we're all obviously subject to a suite of professional and contractual and equitable confidentiality and information security obligations when we handle client information and information from our solicitors. None of that changes, none of that's affected by Brexit. Second, third and fourth points are about the GDPR. Second point, in practical terms, most data protection obligations on barristers are not going to change in the short term. Third point, there is one major area of potential change, which is the receipt of personal data from the European Economic Area, which is presently covered by the GDPR. Fourth point, what you're going to need to do in that area, if you do receive personal data transfers from the EEA, is going to depend on the outcome of some discussions that are currently going on between the UK and the EU. And I'll come on to deal with the detail of that. So the first point, GDPR is not the only obligation. That's obvious, that's done. Second point, most GDPR obligations aren't going to change in the short term. Since quoting convoluted secondary legislation seems to be the flavour of the webinar, the Data Protection, Privacy and Electronic Communications Amendments, etc. EU Exit Regulations 2019 turn the EU GDPR into the UK GDPR without substantially changing its terms. They make some tweaks to the Data Protection Act 2018 as well. In the short term, the public indications are that the government doesn't intend to exercise its newfound freedom to adapt EU law so as to make any substantive changes to the GDPR scheme. So from a practical perspective for barristers, the obligations that are imposed on you and the substantive obligations that you may be litigating about are unlikely to change. They'll just come through the UK GDPR rather than the EU GDPR. The government has published something called the National Data Strategy, which sets out some, which I think it's fair to say are high level, about how it wants a pro-growth legal regime that is not too burdensome for the average company, but also wants high data protection standards within the UK. So there may be some high-level intention to change or depart from the GDPR position in the medium term, but at least in the short term, the substance isn't going to change. There is also a limited category of data, which is essentially data of non-UK data subjects, i.e. people, which has been brought into the UK and is processed in the UK before the end of the transition period, to which the EU GDPR continues to apply under Article 71 of the Withdrawal Agreement. It is probably the EU GDPR frozen in time at the 31st of December. Again, that shouldn't make a substantive practical difference in most cases, because at least in the short term, the UK GDPR is doing much the same thing as the EU GDPR. Third point, the area where there is going to be a change is international data transfers. Under the GDPR as it currently works, there is essentially a data protection bubble that covers the whole of the EEA. And although one has to comply with the GDPR in respect of all processing of data within the bubble, one doesn't have to bother with the specific question of the transfer of data between different jurisdictions. So if I'm in Belgium and I want to transfer data to France, I can do so without going through any special steps beyond the ordinary obligations under the GDPR. The underlying logic being that everything is covered by the EU-wide rules, so there aren't any need for any additional steps. If one wants to transfer data outside that bubble, one has to go through one of the specific legal bases that are set out in Chapter 5 of the GDPR, and I'll come on to talk about a couple of those in more detail. Effectively, what Brexit is doing is moving the UK outside that bubble. And the effect of this is twofold. Firstly, from the perspective of EU law, data transfers from the EEA to the UK are now subject to the transfer regime in Chapter 5 of the GDPR. The basic principle of that regime is that normally data will only leave the EU if it's going to be protected to a essentially equivalent standard to the GDPR, to the EU protections. And that can be achieved in various ways. You can have that through an adequacy decision, which I'll come on to, or through a contractual arrangement where the parties contract effectively to follow EU standards, or binding corporate rules between different companies in a corporate group, that sort of thing. There are some limited exceptions to that basic principle where there is a really important reason to transfer data, but those are limited and specifically set out in the GDPR. The obligation from the perspective of EU law is going to be on the EEA client and is going to apply from the transfer from the EEA client to the recipient. In many cases, that isn't going to be a self-employed barrister. So in a classic example where you're instructed by a French company to bring litigation in England, but there is a firm of solicitors involved, the transfers most of the time will go from the company to the solicitors. But there are, as we all know, circumstances in which barristers are instructed directly by in-house lawyers in large companies, where barristers hold themselves out on the direct access basis, or where, in the context of an ongoing case, a client will send data, potentially including personal data, directly to a barrister without interposing solicitors in that transfer. So there are going to be situations where the EEA client's obligations require it to satisfy itself that the data transfer is lawful from the perspective of the EU GDPR. The second implication of the UK being moved outside the bubble is that from a UK perspective, there is going to have to be a domestic transfer regime. The UK is going to be its own little bubble, and transfers out of the UK are going to be controlled by a new domestic regime. The policy of the government currently is that the EEA is going to be treated as adequate for those purposes, so that's unlikely to prevent a practical problem in the short term. It will continue to be the case that transfers from the UK to non-EEA countries will need to comply with bases for transfer, but it will now be the bases for transfer in the UK GDPR, not the EU GDPR. So the fourth point, what are the options on a practical level for barristers in relation to, and their EU clients in relation to data transfers into the UK? I think it's probably uncontroversial, and it's certainly government policy, that the best outcome from this perspective is an adequacy decision. This is a formal decision by the European Commission that the standards of data protection in the UK are essentially equivalent to those in the EU. There are 9 current adequacy decisions covering the Channel Islands, the Isle of Man, Japan, Jersey is a Channel Island, New Zealand, Uruguay, those jurisdictions. So relatively limited, but the Commission has issued a number of adequacy decisions already. Where one of those are in place, there's no additional requirement. It's as if that jurisdiction is within the bubble, to go back to my constant analogy. Both the UK and the EU have said they want an adequacy decision and they will aim to achieve it in 2020. It's not part of the future relationship negotiations because it's an EU assessment by the Commission, but it's going alongside the negotiations, and Sam will say whatever he can about where we are on that currently. You might think that it should be reasonably straightforward to get an adequacy decision. After all, we're currently a member state, we're currently operating the rules of a member state, and we're not immediately intending to depart from them. There are some clouds on the horizon, because I think it's fair to say that there was concern in some parts of the EU about the UK's data protection regime before Brexit, in particular data processing for immigration purposes and retention and use of data by law enforcement and national security. And various EU institutions have been raising these concerns now and pressing the European Commission to take a tough line. The Commission's job has not been made easier by the fact that the Court of Justice has twice struck down adequacy decisions in relation to the United States, saying that the Commission's decisions didn't comply with EU fundamental rights because of the risk of use of EU personal data by US security agencies. And so there's a certain amount of pressure on the Commission to come to a decision that is not going to be struck down by the Court of Justice in the future. The upshot of all that is that one certainly can't assume that we will get an adequacy decision by the end of 2020, or indeed at all, although well, we'll hear from Sam as to where the negotiations have got to, but my understanding is that they're certainly sort of continuing. If there is an adequacy decision on a practical level, that is, as I say, a basis for transfer that doesn't require any specific steps or authorization. If there isn't an adequacy decision by the end of 2020, but the negotiations are ongoing, then, as I've already said, EEA clients transferring data are going to need a lawful basis to do so. The usual lawful basis, or the most appropriate lawful basis, will usually be what are called standard contractual clauses. These are the parties contracting to maintain data protection standards at the GDPR level. There is a set of standard contractual clauses that have been published by the European Commission and are on the ICO website. And there is some guidance by the Bar Council that was produced last year in the context of no-deal Brexit that gives guidance to barristers as to what they would need to do in relation to the standard contractual clauses. circumstances. The Commission standard contractual clauses are currently being reviewed by the Commission in the light of the second of these Court of Justice judgments striking down the US scheme, but it's perfectly okay to use the current standard contractual clauses. If there isn't an adequacy decision because the UK is assessed as not being adequate, the precise consequences for barristers are going to depend on why the UK has been judged to be inadequate, and what the implications are. There are some circumstances in which it will be acceptable to continue to use standard contractual. There are some circumstances in which it may not be, because those are also subject to the requirement of fundamental rights compliance. That's what the second of these Court of Justice cases sets out. In those circumstances, a lot of organisations will be looking quite hard at what's possible and what's appropriate. And I anticipate that the Bar Council would want to put out further guidance in that situation. There are some specific derogations in Article 49 of the GDPR, and any barrister in that situation being asked about transfers from outside the EU would want to look at those, but they're quite complex and they do require the exercise of judgment by individual barristers. So I think that's probably all I had to say, and I'll hand it back to Rodri and onwards to Sam.
Yes, well, thank you very much, Rupert, particularly as I think you've masterly, I think you're 2 minutes after 6, so I hope it hasn't caused you any problems, but that's you're right. Released if you need to go, which I suspect you do. So thank you very much for that very clear exposition. There are a couple of questions that popped up on the chat, which Ivana and Jonathan and possibly Fergus might want to have a look at, but I'll pass over to Sam to the last presentation in relation to data. So thanks very much to Rupert.
Hi everyone, thank you very much for inviting me to speak today. So I'm from the Department of Digital, Culture, Media and Sport. A lot of what I was going to cover has already been expertly explained by Rupert. So I will try and be brief. If you would just bear with me for 1 minute.
While Sam is out of the room, I don't know, there are two fairly short questions. One is, do you need to serve as well as issue proceedings before the transition period? And the other is the rules in relation to consumer disputes. I don't know whether you want to deal with them. Oh, he's back now. So we'll save them up and give them as your little lollipop to go away with.
Apologies for that. I'll launch into my presentation. So I'm going to share my screen, and hopefully all the technical fatalities will work. Brilliant. So I'm going to provide a quick overview of what you may need to do to prepare for a possible new regulatory environment and new rules around data protection as of the 1st of January 2021. So regardless of whether the UK and the EU agree a trade deal, if you need to continue to receive personal data from the EEA for business use, such as details of payroll admin or customers' email addresses, you may need to take action on data protection. As Rupert's outlined, the EU has an established way of allowing the unrestricted transfer of personal data to countries outside the EU called adequacy decisions. And this is an autonomous process, and it is not reliant on a negotiated trade deal. It's an independent, objective and technical assessment to determine whether a third country's data protection standards are at least essentially equivalent to the EU's. And no other third country standards have ever been close to the EU's. So a current update for the state of things. So the UK is seeking adequacy decisions from the EU, and that assessment is currently underway and steady progress is being made. The UK sees no reason why it should not be awarded adequacy. However, if at the end of the transition period, the UK has not received data adequacy decisions, the free flow of personal data from the EEA to the UK will end, and organisations will need to prepare for any new rules. So to continue to lawfully receive personal data from the EEA, as Rupert outlined, alternative transfer mechanisms or ATMs will need to be put in place as outlined in the EU GDPR. If those protections are not put in place, then EU organisations could be operating unlawfully and face regulatory action. And this could have a knock-on effect for UK businesses, resulting in EU organisations ceasing to send personal data to the UK if the appropriate mechanisms are not in place. So in terms of practical steps, businesses will need to map out data flows with your EU partners and work with them to put in those alternative transfer mechanisms in place. So as mentioned, standard contractual clauses or SCCs are the most common legal safeguard and will be the relevant mitigation for most organisations. So the ICO, the Information Commissioner's Office, have created an interactive SCCs tool for organisations to use, and this is a really helpful tool, and further guidance can be found on their website regarding the steps that organisations may be required to take. One more thing to mention is that the Article 71 of the Withdrawal Agreement contains provisions that apply EU data protection law in its end of transition period state to certain legacy personal data if the UK has not been granted full adequacy decisions by the end of the transition period. So legacy data includes personal data of individuals outside of the UK, processed in the UK prior to the end of the transition period, or subsequently on the basis of the withdrawal agreement. So you will need to familiarise yourself with the data protection provisions of the withdrawal agreement to ensure that you're in a position to comply. So we ask that you please carry out the checks that you need to make to continue to legally receive personal data from organisations in the EU from the 1st of January 2021. And please do allow enough time to complete these actions, as timescales will vary in terms of the complexity of the data flows and also your resources. But please do stay up to date with the gov.uk website. And also, as mentioned, the ICO has lots of really helpful information and an SCCs tool that you can use. And following this webinar, we'll make sure to send out these links. And if you do have any questions, please do get in touch and we'll respond as soon as we can. Thank you very much.
Thank you very much, Sam. I'll check my chats to see if anybody has come up with a further question.
They have.
Yes, indeed. I might raise all three at once. The first from David G. What is the point of SCCs if there's been an adequacy determination anyway? Secondly, from Helen O. What would you use if transferring data with a company USA now the shield is no longer in place? And then Christian, I think, has raised a question himself. Will an SCC help barristers in a case involving parties in the EU and in third countries, for example, the US in light of Schrems 2, even if there is an adequacy decision, and any chance of clarifying the withdrawal agreement provisions on data protection? Well, that's quite a raft of questions. I suspect they're going to be in the rather difficult to answer box, but I don't know if Sam wants to address any of them now, or whether they're points that we might consider with Rupert, and if we've got any answers, we'll give you answers in due course. I don't know, Sam, do you want to respond to any of those?
Yeah, absolutely. I think you're right. We will make sure to have a look at these questions, and we'll get back to you with a response on them all.
Yeah, I think that's fair enough at this time. Can I invite either Ivana or Jonathan to pick up on the two questions I mentioned on their part, which are relatively short and discreet? I don't know if they have an answer to them. You're both muted, I think. Jonathan, I think you need to unmute.
I'm happy to have a go. Certainly, the second one I can certainly answer. I'm more or less what the civil jurisdiction and judgments regulations, if I can call them that, do is to preserve the status quo for consumers and employees. In other words, to take the articles in the recast regulation and to adapt them into domestic law so that they are essentially UK domiciled consumers and UK domiciled employees only that have the benefit of them. So essentially the rule is as before, that there's no real special rule for businesses suing consumers, but where the consumer is the claimant, provided, and there are various conditions, but the one that you encounter more often is where the business is doing business or directing activities, marketing and so forth in England, then a UK domiciled consumer can bring proceedings at their election, either in the where the business is, but more likely and more importantly, a consumer can sue in the UK a business that is directing activities to the UK, regardless, in fact, of wherever in the world that business is located. And jurisdiction clauses in consumer contracts rarely work. They have to either have been concluded after the dispute arose, which I imagine is a very rare event, or they must be clauses that are entirely beneficial to the consumer and of no extra benefit to the business. For example, they say, in addition to the courts otherwise competent, the consumer can also bring proceedings in the courts of wherever it may be, which again must be pretty rare. Or they are clauses where at the time the contract was concluded, both the consumer and the business were domiciled or habitually resident in the same state and chose the courts of that state. So more or less, it's just taking those provisions and enacting them into domestic law so that UK consumers enjoy more or less exactly the same protection that they enjoy today, will continue to enjoy as against businesses from the 1st of January. I don't know whether Ivana wants to deal with the withdrawal. I'm happy to deal with the withdrawal point, but I know Ivana spoke on that subject, so I'm happy either way.
Well, you've got the floor. Ivana is looking at something studiously, so do you want to have a go at it? And if she wants to add, fine.
Yes, I haven't thought about it very carefully, but now I look at it as a very, very interesting question. The judgments regulation proceeds on the basis of when a court is seized. And for the purposes of English law, a court is seized at the time of issue rather than the time of service. The language used in the withdrawal agreement is a language of when proceedings are instituted. Now, from my memory, that's not the first time we've ever seen that. Every time there's a new iteration of the judgments regulation, which has gone from various versions of the Brussels Convention 1968 through to Regulation 44 2001, through to the current iteration 1215 of 2012, they've always had an article near the back of them saying this new regulation applies from the date of when proceedings are instituted after this date. And that term, as far as I know, is never defined. But as a matter of construction, I think it would be very surprising if courts, both in England and the ECJ, didn't say that instituting the proceedings is the same as seizing a court, which in England would mean issuing proceedings before the end of the year. But Ivana may have a different view.
Ivana, I can't tell whether you're frozen or whether you're. I think maybe your communication's not working, but you appear to be on mute.
She's frozen, I think. But I would, for what it's worth, and it's probably not worth a lot, I agree with Jonathan.
Yes. Well, sorry, Fergus, I wasn't in any way trying to keep you out.
I didn't take it as that. I was just covering up Ivana's frozen nature. Yeah.
Well, I see the numbers are dropping to. I don't know whether
Paul
may have something to say. Paul, did you want to comment?
No.
Can you hear me?
Very faintly.
Yeah, I think we have a breakdown in communications with Brussels, which I won't take as any way symbolic. But Paul, did you want to say anything?
I was only going to add, Rodri, that I was on a similar seminar with the Law Society with some family law experts a couple of weeks ago who took the same view that both Jonathan and Fergus have. So whilst that doesn't necessarily mean that is absolutely the view that will prevail, I think it's clear that there is a sort of body of opinion in that direction.
Yes, I suppose there's an interesting question about which the final court to decide this question would be, but I take it from our point of view it would be our own Supreme Court. But we'll proceed on that interesting question on another day. I think that probably brings us to a close, unless any of our speakers have any burning desires. I'll just check the chat to see that nothing else has come up. Oh, there's one thing.
There's Hugh Mercer and Anna Allen.
Yes, the question is, given that the EU Commission takes years to assess the adequacy of national legal systems for the purpose of granting adequacy decisions, how can data controllers with limited resources, SMEs or sole traders, be expected to make those assessments for the purpose of putting in place SCCs? Well, I'm not sure there's any very good answer to that sort of question, any more than what happens if nothing has happened about Lugano in 2 years' time. But I think unless the government representatives want to say anything in particular, I suspect that's just one of the pleasures of taking back control. And we'll have to see how it goes in the future. But I don't think that's not intended in any way as a flippant response, but I think there are inevitably going to be some difficulties over the next few months and uncertainties. But I don't know, Sam, if there's anything more you want to say about that.
I think, yeah, that's it's something I can definitely take back, and we'll get back to you. Okay.
Well, I think there was never going to be an answer to every conceivable question, but in particular in relation to the data questions, I'll discuss this with Sam and Rupert during the course of tomorrow and hope to get back to you with some answers either tomorrow or in the course of next week. But otherwise, I'd just like to thank you all for attending. We've now gone down to 50 again, so I think this is probably a good moment to wrap up and wish you all the best, and I hope you found this a valuable seminar. Thanks very much.
Thank you.
Rodri?